Dr. Fry, let me ask you and also any other member of the panel this question. If an employer becomes aware that an employee is having some kind of psychological problems, perhaps the employee mentions that he or she is seeing a therapist and other comments, she hates her name and she's afraid of Xerox and fax machines. Actually, this is a true story, but what, in terms of the employer's approach to this, but it seems to me there's only so much an employer can do or go so far, such as by asking the employee if the employee needs any kind of accommodation. Certainly that's not illegal. But aside from outright asking the question, what would you recommend be the approach of a concerned employer who really wants guidance on what to do in this situation?
Let me give you a specific suggestion in that regard. There is the potentiality, and I've had a number of individuals referred to me on this basis, and that is to carry out a fitness for duty type of evaluation. In other words, this patient has not been identified as being disabled. This individual, this worker, has not been identified as being disabled, but the potentiality may exist that, as Mr. Bruce has designated here, there's the possibility in the employer's mind that there might be a psychiatric issue involved. And so that under those circumstances, a fitness for duty evaluation can be called for simply by getting in contact with a empaneled, in other words, a psychiatrist who has that authorization to do a consultation with regard to fitness for duty and receiving an evaluation on that basis.
And if an employer wanted to do a fitness for duty, they would have to have some sort of objective basis for believing that there was some reason that this person could no longer do their essential job functions. It can't just be, well, I heard you had a psychiatric diagnosis, so I'm sending you for fitness for duty. That would actually violate the state and federal law. There has to be an objective basis for it. Also, if the person is not showing some objective signs of not being able to do their job, but is rather just being symptomatic at work, but is still doing their job, I would caution employers that you are not the treating physician to your employees, and that if someone's doing their job and does not need an accommodation and happens to have some bizarre, fears or thoughts, but is still doing their job, it's not, really the employer's job to intervene in any kind of medical way. That's really not the role of the employer. The employer should be focused on the job.
And how would, in the same vein, how would you advise an employee who really feels it's personal between her and her therapist? In other words, how much should an employee who feels it's more personal than work-related, at least in her mind, how much would you advise her to say, or that she must say, in order to protect her rights and in order to keep her a job?
Well, I mean, if the person wants an accommodation, then they have to disclose some information to their employer. If they don't want an accommodation, then they don't need to disclose any information to their employer. If they want to self-identify as a person with a disability, they're free to do that, but they don't have to sort of give, line and page and line sites for exactly what their diagnosis is or what their psychiatric history is. They're entitled to keep that type of detailed information private.
And does that apply, Claudia, when someone is applying for a job at the initial interview, where it's certainly not apparent to the employer that there may be accommodations, or that the prospective employee has certain diagnoses which may need accommodation? Would you advise an employee, if it seems more likely than not that they may need an accommodation, to say so to the employer in that situation? Or could you give us any guidance on how much someone should reveal up front?
An applicant is not required to disclose their disability, a hidden disability, during the application stage. Even if they think they might need an accommodation later, they're still not required to disclose. They can wait until they actually need an accommodation, which could be a year later or 2 years later, and then disclose at that time. And so, no, you don't waive your ADA or your state law rights simply by not disclosing. Some people want to disclose because they feel it starts a more honest and open relationship with their employer. You know, the vast majority of people with hidden disabilities choose not to disclose in the application process, I think, for obvious reasons.
Thank you.
There's an employee who's been permanent intermittent for 4 years.
Please, excuse me?
An employee who has been working permanent and intermittently for 4 years, and he's noticed that everybody around him that came in at the same time is now permanent. And he was told by his peers that the only reason why he wasn't picked up was because he doesn't come to work. He doesn't come to work on time. He's bipolar. He's gone through a number of medication changes that has affected his ability to get up and come to work on time. While he is at work, he does well. He wears earphones, sits in the back of the room, and he's been a good employee other than not being able to get at work. Is that a reason for his employer not to pick him up permanently?
What the state and federal laws say is that you can't discriminate against someone, which means treat them worse than someone else without a disability, and you have to provide reasonable accommodations. And you can't discriminate against someone because they need reasonable accommodations. So in other words, let's take away the idea that the person was sometimes late to work and just say that the person wasn't made permanent because they knew that he had bipolar disorder. That would just be your regular garden variety discrimination, just like you would have in a sex discrimination case or a race discrimination case. You can't sort of not make the person permanent or not hire the person because of their disability, bipolar disorder. Then look at the accommodation needs of that person. If that person needs more time off or needs to come in late at times because of their disability, you have to look and see, is that a reasonable accommodation? Does that impose an undue hardship? Is there a real reason that the person has to come at a particular time? Some jobs are very flexible. Being a lawyer is often a very flexible job, which is one of the reasons I like this job that I have, because you have your own projects and your own hours. Someone, on the other hand, who's on an assembly line with shift work, or someone who is a receptionist, is not going to have that flexibility. So showing up right on time is going to be essential to the job. So it really depends on whether that's a reasonable accommodation. If the person is getting a reasonable accommodation for the time off and for maybe coming in late sometimes, then when that person's not made permanent, that raises a real question as to whether or not the person's not being made permanent because they're a person who needs accommodation, who needs reasonable accommodation. Now, the employer could argue, well, we try to reward people based on their attendance, and that's a non-discriminatory policy. It applies to everyone equally. So I could see that going either way in the courts, but that's a very good question.
It's me again. Hi. What you said about employers rewarding people based on good attendance and perhaps thinking, or rightly or wrongly, that somebody who has a spotty attendance record is a bad employee, is actually in some ways a very negative thing for people with a lot of different, not only a psychiatric disability, but a lot of different types of disabilities. Even physical disabilities that don't. I mean, a person could have asthma and maybe need to take off when they have severe attacks. Or there are a lot of other different types of things. So that in itself could be construed as a discriminatory policy.
Yes, and I've actually made that argument, and a number of advocates have made that argument, particularly not so much with the reward ones. Those are a little, I agree with you, but the reward policies are perhaps a bit more difficult to challenge. What I've challenged are the ones that impose penalties, where it says, we have a no-fault attendance policy. If you miss blank number of days, you're out of here. And that's just not, in my opinion, a lawful policy because of the impact it has on people with disabilities who have time off that's related to their disability. They are going to need that as an accommodation. You can't count that accommodation against someone and then terminate them when they hit, their fourth absence or whatever. And I also agree with you that a lot of the accommodations that people need are very similar for psychiatric and non-psychiatric. In the fact sheet on page 5, there's a list of different accommodations that people with psychiatric disabilities will often ask about. And when people with non-psychiatric or physical disabilities call me, almost, I would say, 80% of the time, the accommodations that are needed are basically the same. Changes in hours, changes in job duties, changes around supervision, changes around equipment. So they're all very similar. We tend to divide people, mental versus physical, but actually the needs are very similar.
My question is, it doesn't center around in the workplace, but it centers with the patient and psychiatrist relationship in this context. Is the psychiatrist in advising the patient about their legal rights and disclosure to their employer? Is that within the scope of practice of the psychiatrist, or are they violating a law? In other words, maybe they're not giving the patient the right information, and the patient goes on to apply for a job and goes ahead and discloses their illness where they didn't have to disclose that.
We've actually tried to get mental health providers a little bit more aware of the laws, not because we want them to give out information about the laws necessarily, but because we would like mental health care providers to more actively refer clients to agencies that will give this assistance, and to sort of at least be aware that the laws exist and say to the client, you may want to look into your Family and Medical Leave Act laws, or you may want to look into your ADA rights, and here are some people you can call to find out more about that, or here's a website you can go to. Probably, for a lot of mental health care providers, they're busy keeping up with their own professions. They may not have enough time to keep up with the legal developments around medical conditions. So they may end up wanting to refer rather than give direct advice. The other way that it's important for mental health care providers to assist is in medical documentation. If someone is seeking an accommodation and they need a doctor's note, I believe it's part of the, assuming it's a truthful note, I believe it's part of the mental health care provider's role to provide that note, and not to say, well, I don't do notes. I think that that's part of the practice, is to provide truthful documentation to assist the person in enforcing their legal rights.
I'd just like to add two issues that have already been. One thing that is needed to the person who might be having that question in their mind needs to know that an individual like myself, who is doing disability evaluations as a psychiatrist, is by law, by state law, forbidden to do therapy work with those individuals who come to him for the evaluation. In other words, there's a wall between therapy and evaluation. Now, the other thing is that I certainly would agree with Claudia with regard to the referral to authoritative sources of information that, as was suggested, psychiatrists, generally speaking, don't have a very clear picture. I mean, what we do, I've been on both sides of this issue here, practiced as a therapist for many years, almost 40 years. And I've been doing disability evaluations for 15 years. So, I'm looking at my experience as a psychiatrist, as a treater, as a therapist, and realizing now, as I've been an evaluator for these past 15 years, how little I knew and how poorly equipped I was to make any kind of informative and valuable recommendations to the patient who was asking a question of that sort, other than to refer them to agencies or individuals who are experts in those fields.
Claudia Byrd is our vocational expert on the panel. And Claudia, now that Claudia Center has set some legal parameters and frameworks around state and federal laws, and Dr. Fry has given us some kind of a context to address disorders, functional limitations, or conversely abilities of individuals. You are the person who places job applicants in positions, and therefore must look at the employer's needs as well as the limitations of individuals who have mental impairments or mental or physiological impairments. Can you tell us from a practical point of view, in other words, from the real world, how you go about this?
I was going to approach it as a utopian. Just how it's supposed to work objectively. And I guess it isn't a utopia. Basically, there's what I call, I try to organize it in terms of matching the employee with the employer, hoping that it's a twofold process. That the employer is looking to find an employee to do a certain job, and they're going to fill that job objectively, and the employee is going to be interested in that job and fulfill the employer's needs, and vice versa. So I actually have a 5-point process, and basically before someone is hired, I do recommend that, and it's not required by law, is to do an essential functions job analysis, which sounds really difficult, but it's not. And to objectively put down, what the essential functions of a job is, what are the marginal functions, and for that employer to honestly and objectively assess what is essential, what is not essential. An employer is not required to accommodate an essential function. For instance, if 90% of the job or 50% of the job is Xeroxing, the employer is not required to accommodate the Xeroxing. If Xeroxing is 5% of that job, the employer objectively should analyze, would it be possible to give that task to another employee? Also, employers are not required to make accommodations if there's less than 15 employees. So basically, if it's a really
5 in California.
5 now?
In California.
God, they give us updated information. So it's 5 now. Okay. It used to be pretty 15. Okay. Originally 23. Basically, workers' compensation deals with people who have had industrial injuries. ADA has come into play with that in terms of workers' compensation. Someone's been injured on the job, for the employer to reasonably look at modified alternative work for that employee. They must put it in writing, if it doesn't exist, in order for the CAP to start under vocational rehab. So it's sort of like a twofold process, because I work in the workers' compensation arena and disability management. The answer is to put in writing if you want a reasonable accommodation. A lot of things are not done in writing, and request in writing what you want to be reasonably accommodated for, because hearsay never really holds up. Also, to realistically see if you can meet those essential functions of the job. To ask what the essential functions of the job are. And if you feel that you're being totally discriminated against, follow it further. Say, I feel that I'm able, to perform that job. Why aren't you giving me the opportunity to do it? You don't have to divulge information in the interview, and that's another good reason for an employer to have an essential functions job analysis. The employer can provide to you what actually consists of doing this job, and you can reasonably contemplate whether you can fulfill the needs or not. It shouldn't be so unclear.
Let me interrupt you just for a second. A lot of employers are business people, and they're interested in productivity.
Exactly.
How do you, when you're trying to place someone, deal with this mindset? In other words, why even consider somebody who's impaired when their job is to make money and to produce? Is there any technique that you use as opposed to just moving on to somebody else who maybe have a kinder heart? What do you do in those situations? It would seem to me it would be a common obstacle out, as I say, in the real world, in that employers would think, why hire someone who's mentally impaired? It'll lead to productivity decline. Has that happened in your experience, and how do you deal with it?
How do I deal with it? Well, I've worked with individuals who have psychiatric disabilities. How do you deal with it? To simplify it, to do an essential functions job analysis. An employer has to be competitive. They can't let productivity go down. I mean, in some cases, if the employee fits the position, I would see it be more positively productive. Mm-hmm. If that employee meets the fulfillments of that job, the essential functions of the job, there used to be more popular in terms of job coaches. You take each individual, you just don't classify people into stereotypes. You take each individual and you try to define what their needs are. You take a person, you don't just clump everybody together. And I don't know if that answers your question.
Well,
an employer does not want productivity to be cut down.
Well, assume an employer does have a stereotypical image of someone who's impaired that, by definition, it's going to cause productivity decline. For example, why hire a crazy person? You're bringing in baggage, unknown baggage. Why take the risk?
Because
Does this come up?
As a vocational consultant, if I work with employers, I'm not going to call the employer up and say, I have a crazy person, but I think they can do the job.
Pardon me? Crazy person?
I'm sorry? I'm not going to say that. Each person is an individual, and I would call up the employer indicating that I have somebody who will meet the qualifications of your job.
I guess I'm talking from the employer's perspective, not that you would call.
Well, I don't divulge. I'm not supposed to. I can't say what
so then
the
your
individual.
Your technique would be to try to place your client
Right.
with an employer without necessarily getting into possible accommodations or limitations of your client, if at all possible, so that you don't even get into that question.
Unless sometimes I do, if there is a question, if the employer isn't specific enough on what the qualifications of the job.
Yes, was there a question?
Yes, I have a question. My name is Richard Green, and my friend here is James Costello. And yes, I am. And we happen to be on SSI, and we are both considered bipolar, schizophrenic, and we We have part-time jobs, both of us. But what are you talking about? What are you doing? Where are you guys going with this?
The point that I was trying to get at, and I think it's an important point, is that people with mental impairments are at least 2 decades behind where the people with physical impairments are now in relationship to equal rights in terms of disability. These days, most people can realize that if there's the paraplegic or quadriplegic and they can't go up steps, that they need to get access to the employment place, and it's obvious. I mean, we all think of disabled people as visually impaired, hearing impaired, paralysis, etc. But the reality for many people in the business world is that they don't have an awareness or understanding of how someone who's mentally impaired can work. In other words, it's a stereotype, and it's unfortunate, but I believe it is reality, that their first question is going to be, what do you mean go to a seminar on how to accommodate people with psychiatric impairments? Why would I want to hire someone who's a manic depressive?
Well, basically what I'm saying as a vocational consultant, that I work with, basically sometimes I don't even read the medicals until after the initial appointment, is to not classify people, is to just do it on an objective standpoint. It doesn't matter if somebody has an orthopedic disability or a psychological disability, is in terms of being objective. The essential functions job analysis is to be more objective. And there are cut downs where you indicate where somebody can do the cognitive functions of a job, the physical functions of a job. Instead of labeling, is to approach it objectively. And I find a lot of people aren't doing that. So I
the
wouldn't,
labeling,
so
the
nobody
labeling is
would,
one thing that
That
would
we're
be
still having
detrimental
to-
to the process.
Definitely
In other words, don't label, don't use the word bipolar. Think about the person's positive abilities. And
crazy.
who did?
You did.
I meant that, no, I wouldn't approach an employer and say this person has a back injury, or I would never use the word crazy. You must misunderstood that. I'm just saying that I don't approach employers. It's against the law to let what anybody's disability is, whether it's back injury related, neck injury related, carpal tunnel, repetitive stress injury, bipolar disorder.
Let me share an experience of personal prejudice that I had and wasn't aware of when I first started my psychiatric practice back in, I think it was 1954 when this happened. There was a lady who came to me who had been divorced 7 times and was in her 8th marriage. Okay, and each one of her mates was a different person. So, I'm thinking, oh my God, here she's had 7 failures in her life, and she's heading into an 8th one. What a loser here. This woman's got all these problems, and she must be really a difficult mate to have gone through all these traumatic experiences. My consultant said to me, now wait a minute, he said, you're jumping off the wrong conclusion, off to the wrong conclusion here. He said, she has been through, 8 marriages and 7 divorces. But what this means is that she has assets and abilities that have made it possible for her to attract 8 different men to become her mate. and live with her under marriage. And I thought, geez, that hit me like a wave of, you can see I remember, it's been quite a few years ago, I can remember that as clearly as if it were yesterday. That really opened up my eyes to a lot of issues that are being talked about here. The thing about anybody who's had a psychiatric disability, whether it's only a temporary one and you recover to a position of being able to carry out the job that you're working before, or whether it becomes a permanent disability that requires a reasonable accommodation, whichever. You, as a result of your experience, have learned some very important things, and you've developed a different level of sensitivity than you had prior to your breakdown, your decompensation. That people who have had disabilities, whether they're temporary or permanent, have learned something. They bring assets into a job that did not previously exist and may not exist in other individuals who have not been through a disability experience.
Thank you, Dr. Fry. Let me throw out to the whole panel a hypothetical question that I've come up with, which covers many of the issues that have been discussed. Assume Mary, an employee, has anxiety attacks if confronted with the public, and her job at the company only involves minimal interaction with the public and other people. However, a colleague of hers is ill for a month, and therefore Mary has to substitute in, and her duties change. She has several panic attacks in a day. It takes therapy and a month of therapy, in fact, for her to recover to the point where she can resume her old duties before her colleague became ill. In the meantime, during the month in therapy, the employer hires a temp and then offers her a lower paying job, that is Mary, a lower paying job, so that she can hire the temp. Mary quits. What are her rights? What can the vocational rehabilitation counselor do based on this work history in getting Mary a new job, assuming that bad blood has developed in this work community? And generally, how can we estimate a length of decompensation in a situation like this? I believe the last part of that would be directed to Dr. Fry, the rights the Claudia Center, and what the vocational rehab counselor can do in this situation, given the work history, to replace her, would of course relate to Claudia Byrd, our vocational expert. Claudia Center.
Okay. Well, if we assume that Mary has a disability and she is unable to perform the job of interacting with the public, you'd have to look and try and figure out, is that an essential function of her job? It seems like ordinarily it's not an essential function of her job, which is why she's been so successful in this hypothetical. When her colleague goes on, I guess, sick leave and they reassign the interaction with the public, I would be very skeptical of that decision, and I'd want to see, why did you reassign that to Mary? Why didn't you get someone else to do that job? Why didn't you hire a temp for Mary's coworker who could do all of the coworkers' work, including interacting with the public? And the fact that they were able to access a temp indicates to me that that would be a reasonable way to deal with the solution, rather than assign a job duty to someone who can't do it because of their disability. In terms of her being basically demoted to a lower paying job, assuming that the accommodation was a reasonable accommodation, that she not interact with the public, that would then be some sort of I would call it an adverse action or discrimination under the state and federal laws. However, she quit, which we never recommend as a legal point of view. We like people to get fired, not to quit. If you quit, basically the courts tend to say, well, it was your decision to leave and maybe they did something wrong before you left, but you quit, and so that really can limit the amount of recovery you would have as a legal matter. But, you know, technically, they probably violated the state and federal law in terms of assigning her the job duty rather than assigning it to someone else, and also demoting her.
Thank you. Dr. Fry, this is an example, I guess, of decompensation where the causative instance may be that somebody got ill and she was just reassigned, which in turn caused decompensation. Is there any way to estimate the length of decompensation in this kind of situation where someone has an anxiety disorder, panic attacks? I mean, is there any average or rule of thumb or any way to predict this, or is it solely an individual thing that no one would have any way of knowing? It was only for a month in this example. Is that long or short?
Well, there's so many other factors you have to take into consideration. The availability of medical facilities is another, and that's why I did bring in this issue of what's going on with insurance companies and attempts to lobby legislation on the part of the American Psychiatric Association that recognized is the difficulty, the barriers that HMOs and health insurance providers create with regard to access to appropriate treatment. And ever since our friendly, I will have to restrain myself, our previous governor, Ronald Reagan, started the destruction of the Short Doyle network for therapy in the communities during his governorship. We've had a problem in my profession with the issues, the socioeconomic issues of the profession and the provision of health care to the extent that is required in the public. Now, there is one other feature that I'm interested in regard to this particular question too, and that is the issue of what's going on in the employers or the manager or supervisor. In other words, whatever the executive, whatever level the executive had, who made these kind of decisions that Mr. Bruce has been describing. And what's going on in that person's mind? What has prompted this individual to behave in that form? And I think that this is a feature that I would like to bring out with regard to the role of a superior in his or her responsibilities in these sort of situations. Good supervisors, I use the word supervisor as the rubric under which I'm discussing these individuals. Good supervisors are people, in my estimation, who have more than seniority, more than having a love affair with the manager, more than playing golf with the executives, more than eating barbecue and drinking beer with the CEOs. Good supervisors are people who have experience in communication training, who are aware of the significant responsibilities of their jobs, their own jobs, are aware of the potential impacts of their behavior on those employees who report to them, and respect the rights and sensitivities and the commitments of their employees.